Hi, and welcome to part 10 of my reading of the Rape Gang Inquiry Report. Today we are continuing on at the recommendations. The evidence presented to this inquiry by victims and whistleblowers demonstrates that beyond reasonable doubt that rape gangs operated with either the active or passive consent of public authorities. More or less every institution failed. The state knew the patterns and recorded and then often destroyed the evidence of harm, and chose political convenience over child protection. Any government that aspires to restore justice, eliminate the gangs, and protect the next generation must implement the following recommendations. Only then can the British state begin to make up for its profound betrayal of hundreds of thousands of British children. Criminal justice response. Victims must be placed at the centre of the criminal justice process. They must have the right to be informed of all decisions, to attend sentencing hearings, and to submit victim personal statements that carry statutory weight. Independent sexual violence advisors must be funded nationally and assigned to every grooming gang victim from the moment of first report. Sentences. Current sentencing guidelines are grotesquely inadequate for organised child rape. The Sentencing Council must be required by statute to revise its guidelines so that child-based sexual exploitation carries a starting point of life imprisonment with a minimum term of 50 years for ringleaders and 25 years for participants. Racial or religious motivation, multiple victims, trafficking across counties, pregnancy caused by rape, and the use of filming or blackmail must each be spelled out as a statutory aggravating factors that push sentences towards their maximum extent. Concurrent sentencing must be prohibited where multiple victims are involved. Cumulative sentencing must be the default. A number of politicians, including Rupert Lowe MP, have also called for a referendum on reintroducing the death penalty for the most heinous crimes. There is a case to be made that this is more than proportionate where rape gangs are concerned. Immigration, deportations, and denaturalisations. Every foreign national convicted of group-based child sexual exploitation must at the very least be deported. Any British citizen convicted of these offences who holds dual nationality must lose their citizenship automatically upon conviction, rendering them liable for deportation. This ought to apply retrospectively to those convicted in the past too. The Home Office must publish annual deportation figures broken down by national background and offence type. Where a perpetrator has family members in Britain who have supported, harboured, or failed to report the offending, the entire immediate family unit must also face deportation proceedings themselves, unless they can prove either active cooperation with the authorities or no prior knowledge. The evidence from witnesses, convictions, and the Casey audit show a clear overrepresentation of Muslim men, particularly of Pakistani heritage, in these organised networks. The inquiry has not ignored this. Mosques, madrasas, and community organisations that have harboured or failed to report perpetrators must face investigation and, if found guilty, be closed. The immediate deportation of anyone nested within such subcultures promoting attitudes that dehumanize non-Muslim girls must be pursued. The nations of the world are not identical. Ultra-selective border control, attentive to the general patterns in sending countries, is therefore also vital to the long-run happiness and continued existence of host peoples across the West. Immigration policy must immediately reflect the evidence. Anyone from a country whose nationals are disproportionately represented in rape gang convictions must no longer be entitled to a visa. This should be applied ruthlessly. Our young girls must come first. Children giving evidence. Special measures for child witnesses in grooming gang trials must be strengthened. Pre-recorded evidence, remote testimony, and screens must be the default. Cross-examination that re-traumatizes the child must be prohibited. The court must appoint a specialist intermediary in every case. The Crown Prosecution Service. The Crown Prosecution Service must create a dedicated national unit for group-based child sexual exploitation, with specialist prosecutors trained in trauma-informed practice. Charging decisions must no longer be influenced by community impact or fear of racism allegations. Failure to charge a clear case must be reviewable by the Attorney General and should result in criminal liability for those who do not carry out their duty. Overseas Task Force. It has been established that organized gangs, chiefly of Pakistani heritage, have not only groomed, raped, and tortured thousands of women and girls across Britain, but have also trafficked such victims overseas, particularly to Pakistan and other countries. Evidence from independent hearings, early day motions in Parliament, and of course survivor testimonies presented to this inquiry serve to suggest as much. The intent by perpetrators was to exert near total control, prevent disclosure of the abuse, obstruct homegrown investigations, and continue inflicting abuse in environments with weaker safeguards. The full extent remains under-investigated due to historical institutional failures by police, councils, and social services, often linked to the concerns over racism allegations or inadequate cross-border cooperation. This must be rectified. It is therefore recommended that a dedicated task force be established within Foreign, Commonwealth and Development Office, FCDO, working in close liaison with the Home Office, police forces, and the National Crime Agency and international partners. This unit should prioritize the identification, location, safeguarding, and urgent repatriation of affected British women and girls. That means enhanced consular support, intelligence sharing on missing persons cases, recording in known grooming hotspots, targeted reviews of passports and travel records linked to known perpetrators, and diplomatic pressure on destination countries for victim extraction and evidence gathering. Compensation. A national compensation scheme for grooming gang victims must be set up at once. Something similar already exists in the form of Criminal Injuries Compensation Authorities, CICA, established in theory to seek compensation on behalf of people physically or mentally injured because of a violent crime in England, Scotland, and Wales. The CICA does so by suing authorities or perpetrators directly, but has proven time and time again to be unfit for purpose in all sorts of ways. Despite providing evidence that helped convict the leader of the Rotherham-based rape gang, Sammy Woodhouse was refused compensation by the CICA on the grounds that she had consented to her own abuse. In our view, awards should be updated to reflect the lifelong harm documented in survivor testimony, including loss of education, employment, mental health, physical health, and family life. The scheme must be funded by a levy on all convicted perpetrators' assets and by the defined benefit pensions enjoyed by any public servants, either within police forces or social services found guilty or dismissed for culpable negligence. Family. The law must place the protective family at the center of safeguarding. As such, the core principle that should underpin safeguarding reform is recognition that a child's family tends to represent the first, strongest, and most effective line of defense against exploitation. While there are circumstances in which children cannot safely remain with their family unit, exploitation cases generally differ from traditional intrafamilial abuse models. Present safeguarding systems do not always reflect this distinction. Families may experience responses that frame them primarily as contributors to risk rather than as potential safeguards against it. This can result in reduced trust between families and professionals, parental disengagement from safeguarding processes, and delayed information sharing, increased isolation of the child from protective relationships, and perpetrators exploiting divisions between children, families, and agencies. Official research increasingly reinforces relational approaches to child sexual exploitation, recognizing that protective networks, including parents, siblings, extended family, schools, peers, and community relationships, are central to reducing vulnerability and disrupting exploitation. Once removed from family and community networks, children as a general matter become more vulnerable to grooming, missing episodes, trafficking, and other forms of harm. A family-first approach, therefore, is essential. We recommend the construction of a safeguarding framework in which families are recognized as primary protective factors. Wherever safe, family support is prioritized, contextual safeguarding approaches are strengthened, and residential care is used proportionately and as a last resort rather than as the default response to exploitation risks. This proceeds from the understanding, bolstered by our inquiry, that where rape gangs are concerned, parents and carers are more often protective than causative agents. Needless to say, this family-first approach should never prevent decisive intervention in cases where home environments are deemed unsafe. The point is that safeguarding authorities must first establish the unfitness of some family environment before residential placement becomes the response. Parents ought to also have a statutory right to be informed of all risks to their child, to receive copies of all assessments and plans, and to challenge any decision that undermines or removes their parental responsibility. Financial and practical assistance, including emergency housing relocation where needed, must be made available to any parent reporting grooming indicators. The state should not interfere with a family's ability to protect itself from harm. The legislative response. The existing legislative framework is fragmented, inconsistently applied, and deliberately blind to ethnic and religious patterns documented in this inquiry and the KC National Audit. As we have noted above, the Sexual Offences Act of 2003 and the Modern Slavery Act of 2015, among other relevant statutes, already contain powers that were never used to any significant effect against the rape gangs. Ethnicity recording, too, remains either patchy or absent. Group-based child sexual exploitation is not even a distinct offence with its own sentencing guidelines. The result is a system that records thousands of individual offences while concealing, deliberately or otherwise, the organised nature of the predation. A single comprehensive Childhood Sexual Exploitation Act must be enacted at once. This new statute should create a specific offence of organised group-based child sexual exploitation, understood as participation in networks that groom, traffic, or exploit children for sexual purposes, whether or not each individual act can be separately proven, with mandatory minimum sentences and aggregating factors for racial or religious motivation. It must reverse the presumption that a child can ever consent to sexual activity with an adult, especially in a grooming context. Courts to date have recognized that apparent acquiescence may be the product of coercion or psychological manipulation, but the statutory formulation has not fully reflected this aspect of CSE. It must also impose a statutory duty on every relevant public authority to record and publish the ethnicity, immigration status, nationality, and religion of both victims and perpetrators in all such cases. This would entail speedy repeal of any legislation that forbids authorities from collecting relevant ethnicity and religious data. Last of all, it must criminalise, as we shall elaborate below, any provably culpable failure or refusal to do on the part of the public officials to act on rape gangs for fear of inflaming community tensions or inviting anti-racist media scrutiny. This would build upon existing principles concerning misconduct in public office, but provide clearer and more enforceable standards. Parliament should mandate enhanced sentencing for offences committed as part of organised networks, including minimum custodial terms and the expanded use of whole life orders in extreme cases. The gravity of such offending, often involving prolonged abuse, trafficking, and commercial exploitation, justifies the harshest possible sentences. A broader constitutional question arises concerning the interaction between human rights law and the prosecution of organised sexual exploitation. It is frequently argued that existing rights frameworks have been interpreted in ways that inhibit robust enforcement or contribute to an institutional caution. A comprehensive review of the Human Rights Act 1998 should therefore be undertaken with the view to recalibrating the balance between individual rights and the protection of vulnerable victims. Reform should focus on ensuring that rights-based arguments cannot be deployed to obstruct investigations, prosecutions, or deportation proceedings involving serious sexual offending. Indeed, it is probably preferable to repeal the Human Rights Act of 1998 than to allow it to continue in its current form. The Equality Act of 2010, if not appealed altogether, should never be applied to criminal justice and safeguarding context. Anti-discrimination principles must not operate as a deterrent to the identification of risk patterns or the enforcement of criminal law. Short of full repeal, at the very least, legislative amendments should clarify that equality protections can neither be invoked to shield criminal conduct nor to restrict lawful investigation practices based on evidence-led assessment. Preventative mechanisms must be significantly expanded to address the evolving nature of child sexual exploitation, organized grooming networks. At present, the criminal justice system remains heavily reactive, intervening most decisively only after serious offences have already occurred and victims suffered lasting harm. While prosecution and punishment remain essential, greater emphasis must be placed on early intervention, disruption, and risk management in order to prevent abuse before it escalates. One vital reform would be to ensure the wider and more proactive use of sexual risk orders, SROs, and related civil preventative orders. In principle, these powers allow authorities to impose restrictions on individuals who demonstrate concerning behavior characteristic of sexual abusers, even where a criminal conviction has not yet been secured. Greater readiness to deploy them would give police officers and safeguarding agencies more confidence to intervene sooner rather than later, whether by restricting contact with vulnerable children, monitoring online activity, limiting access to certain locations, or preventing association with suspected grooming networks. Such measures would help close the gap between suspicion and prosecution, where many offenders currently continue operating unchecked. For similar reasons, compulsory monitoring arrangements for high-risk offenders should be strengthened. Individuals with histories of sexual violence, exploitation, trafficking, or organized abuse should be subjected to more rigorous supervision through electronic monitoring, regular risk assessments, mandatory disclosure requirements, and closer multi-agency oversight. Given the increasingly digital nature of grooming, monitoring should also include online behavior and communications where legally proportionate. Enhanced supervision would not only reduce opportunities for reoffending, but also improve intelligence gathering on wider criminal networks. Mandatory reporting duties for institutions represent another crucial preventative safeguard. Schools, social services, healthcare providers, care homes, charities, and other legal organizations working with children should be placed under a clear legal obligation to report suspected abuse, exploitation, or grooming activity to the appropriate authorities. Too often, institutional failures or fear of reputational damage or uncertainty about procedures have allowed warning signs to be ignored. A statutory duty would create greater accountability, encourage earlier referrals, and strengthen interagency cooperations. Failure to report serious concerns, particularly by professionals in positions of trust, should carry meaningful disciplinary and potentially criminal consequences. Expanding preventative powers must, however, remain consistent with principles of proportionality, due process, and basic freedoms. Safeguarding, including judicial oversight and regular review mechanisms and clear evidential thresholds, are necessary to ensure that expanded powers are not used arbitrarily. Nevertheless, where the protection of vulnerable children is at stake, the balance of public policy should favour earlier intervention rather than waiting for irreplaceable harm to occur. Finally, the overarching legislative objective should be to recognise organised sexual exploitation as a form of structural criminality. This requires a shift in both legal doctrine and institutional culture. The law must move from reactive punishment to proactive eradication of networks that exploit vulnerable children. Without such a shift, existing statutes, however numerous or severe, in theory, will continue to operate as instruments of retrospective justice rather than effective protection. The following principles must be enshrined in the aforementioned Childhood Sexual Exploitation Act. Children can never consent. The Act must prohibit any agency, or court from treating a child's previous behavior, clothing, intoxication, or lifestyle choices as mitigation or consent. Any professional who uses such language in reports or proceedings must face disciplinary action and potential criminal sanction. Accountability encourages competence. The Act must contain greater clarity in law detailing the positive expectations to which public-facing bodies with the statutory duty of care must be held accountable. Among frontline professionals, it is of course everybody's duty to safeguard children. The clarification should be such as to require the relevant duty holder, be it an individual, an organisation, or some other entity, to take proactive, affirmative steps to save children from group-based exploitation. Breach of this duty, whether by provable incompetence or deliberate malpractice, must be an offence. Repeated failure to act on known safeguarding indicators has been one of the defining characteristics of the grape gang scourge across Britain. Public bodies must therefore face clear legal accountability where serious neglect occurs. Crimes committed by child victims of grooming at the behest of their abusers lack the mens rea, guilty mind, to count as criminal in the conventional sense. The Act must expunge the criminal records of any child or young person convicted of crimes including prostitution, drug possession, or public order offences that occurred while and because they were forced to do so under the presumption. The presumption must be that such convictions were direct results of either manipulation or coercion. Named Sammy's Law after Sammy Woodhouse, this would be for the benefit of survivors in need of closure who were criminalized instead of protected. Proven rapists forfeit their parental rights. The Act should make it unambiguous that rapists, upon conviction, automatically lose their parental rights over any children born of such rape. Sharia marriage. The Act must prohibit Sharia marriages. Too often, these have served as a pretext for abusers to exercise greater coercive control over their victims. This is because Sharia courts effectively operate as a parallel judicial system recognized in British law but not of British law. This enables them to govern the life of Muslim communities and, by extension, the life of any victim groomed by such communities in ways counter to our long-established norms and customs. All frontline response. Every frontline professional, police officers, social workers, teachers, GPs, nurses, taxi licensing officers, school staff and youth workers must receive mandatory annual training on group-based child sexual exploitation. This training must convey the documented ethnic and religious patterns, the tactics used by gangs, the signs of grooming, and the legal duty to act. Failure to act on clear indicators must carry a professional risk, in serious cases, criminal consequences. A national public awareness campaign must be launched so that parents, neighbours, and communities know exactly what to look for and whom to contact. The default response of every agency must shift from disbelief and victim blaming to immediate protection and investigation. While policy change is required to hold statutory services to account, the delivery of these practices must be carefully monitored. Improved training is key. Many initiatives emphasize the need for multi-agency working, but delivery more than emphasis is essential to effective safeguarding in practice. Previous reviews have documented gaps in multi-agency processes. many of them noticed as a result of failures of child safeguarding. A crucial point to consider is that each service has its own guidelines, practices, and processes, all of which contribute to gaps in communication, referrals, and the like. It is important that statutory services form trusting relationships with one another as well as with other parties. This means engaging in open conversations, demonstrating professional curiosity, and erring on the side of oversharing information to safeguard children. In 2022, the British Journal of General Practice published an article on the work of Sharon Dixon, Bryony Kendall, Jenny Driscoll, and Catherine Pope. Relationship building is at the heart of multi-agency working. It read, and sharing stories and findings can be part of this. When research is primarily conducted and shared within single agency professional meetings and publications, opportunities to do this may be missed. This buttresses the findings from the inquiry. Cross-agency training is vital to facilitating multi-agency work. Therefore, we recommend that the cross-agency child safeguarding training must be made mandatory for all statutory services. The inquiry further recommends that agencies work together to agree joint working practices and policies to prevent confidentiality acting as a barrier to sharing pivotal information in circumstances that may not only serve to protect children but prove life-saving. Safeguarding posters outlining signs of child grooming and exploitation should be displayed in public areas in all health clinics, including GP surgeries, sexual health clinics, and A&E departments, inpatient areas and mental health clinics, and any other area accessed by those attending healthcare facilities. This should be extended to schools and youth centres. Policing must be reformed from the ground up. Every force must be required to record the ethnicity and immigration status, nationality, and religion of both victims and perpetrators in all CSE cases. A national marker for group-based child sexual exploitation must be mandatory. Specialist CSE units must be established in every force with dedicated resources for proactive disruption. Ethno-religious lobbying against proper law enforcement must be resisted on principle. Policing. The current framework within which law enforcement approaches CSE is untrue to the real-world nuances of the problem. In order to perform better, the police must deepen their cooperation with the existing multi-agency CSE panels, assigned to identify and safeguard children at risk of exploitation. At present, these efforts take place largely at the local level, without sufficient coordination. Multi-agency CSE panels also lack either a statutory footing or a national mandated operational framework. As a result, performance varies from place to place. Evidence from serious case reviews and major inquiries, including those arising from investigations into the Rotherham and Rochdale gangs, indicates that the lack of a consistent playbook set down nationwide contributed to safeguarding failures and undermining local responses. We therefore call for the immediate introduction of multi-agency coordination on CSE and a uniform operational framework. Such reforms would improve consistency and maximize accountability, where effective multi-agency CSE panels tend to demonstrate well-defined referral thresholds and pathways, regular strategic meetings between the police departments and children's services, and clear lines of accountability. Norfolk is often praised for its track record on these very fronts. There exists a dedicated multi-agency exploitation team embedded alongside policing. The proven model of such success stories must serve as a foundation for any future reforms. Police should also be trained to interview rape gang suspects in relation to their religious belief and investigate the witness evidence of victims in relation to the religious elements of their abuse. The fear of offending cultural sensitivities should be removed completely from the culture that permeates modern policing. Healthcare. The NHS must be specified in law to owe a duty of care to survivors of rape gangs. Every sexual health clinic, GP surgery, A&E department and mental health service must trigger an automatic safeguarding referral for any children presenting with STIs, genital injuries, pregnancies, or repeated self-harm linked to exploitation. Discharge of a child back to known risk environments without a multi-agency protection plan must be prohibited. Trauma-informed care must be commissioned nationally for all rape gang survivors. Backstreet abortions and pregnancies caused by rape must be treated as crimes, not private medical matters. In March 2026, the government published an updated version of Working Together to Safeguard Children, a statutory guidance manual on a multi-agency working to help support and protect children. The guidance provides a summary of changes within this updated version, as well as an appendix glossary on group-based child sexual exploitation. The glossary defines group-based child sexual exploitation as two or more individuals, whether identified or not, who are known to or associated with one another and are known to be involved or to facilitate the sexual exploitation of children. Being involved in the sexual exploitation of children includes, example, introducing them to other individuals for the purposes of exploitation, trafficking a child for the purpose of sexual exploitation, taking payment for sexual activities with a child, or allowing their property to be used for sexual activities with a child. This can be perpetrated within or beyond the family by both children and adults, and groups can be organized or loosely linked. Trauma-informed care must also be commissioned nationally for survivors of organized sexual exploitation. Survivors frequently experience long-term psychological trauma, addiction, self-harm, homelessness, PTSD, depression, and difficulties engaging with healthcare services. Yet support provisions remain inconsistent. An overwhelming number of the participants with whom we engaged during the inquiry have reported struggles with accessing appropriate psychological support to process their trauma and facilitate recovery. Survivors need more specifically focused attention than is customary with cognitive behavioral therapy. This report recommends that compassion-focused therapy, CFT, should also form a central component of therapeutic provision for survivors. Survivors commonly present with profound shame, self-blame, disassociation, emotional dysregulation, complex trauma symptoms, substance dependency, depression, self-harm, and difficulties forming safe interpersonal relationships. These psychological patterns are not incidental. They are frequently the direct consequence of prolonged coercion, humiliation, degradation, violence, and institutional abandonment. CFT specifically targets these psychological patterns, grooming processes, deliberately condition victims to internalize guilt, complicity, worthlessness, and emotional dependency upon perpetrators. Many survivors consequently describe themselves not primarily as victims of violence, but as dirty, weak, complicit, or beyond help. These shame-based feelings persist even after physical safety has been secured. CFT directly seeks to strengthen this soothing system through compassionate imagery, emotional regulation training, and attachment repair, and reduction of self-attacking cognition. Emerging evidence suggests that compassion-based interventions are effective in reducing PTSD symptoms, shame, depression, and self-criticism among trauma survivors. Importantly, many survivors of organized exploitation distrust authority figures and struggle with conventional clinical relationships due to repeated betrayal. CFT offers a non-punitive and non-pathologizing framework that validates survival responses rather than framing victims as dysfunctional or resistant. This is particularly important for survivors previously criminalized, disbelieved, or blamed by professionals. In view of these facts, CFT should be commissioned nationally within specialist survivor services. NHS trauma pathways should include CFT as recommended intervention for survivors of organized sexual exploitation. Clinicians working with grooming gang survivors should receive specialist training in shame-informed and compassion-based approaches. Long-term therapy provision should be prioritized over short-duration crisis interventions. Survivor services should incorporate peer-based compassionate recovery models alongside formal psychotherapy. Support should also be made available to family members, especially to children and the partners of victims of gang-based abuse. As for physical health, pregnancies in children under 16, abortions following suspected rape, concealed pregnancies, forced terminations, and suspected backstreet abortions should be treated as safeguarding and potentially criminal matters rather than solely private medical episodes. The child must always be regarded as a victim in need of protection. As we have seen, the physical after effects of exploitation did not end when the abuse itself ended. In many cases, as we have seen, the trauma carried over into the lives of children born through rape. The continued institutional invisibility of these children reflects a broader reluctance to confront the wider human consequences of organized sexual exploitation. As such, these children should be formally recognized within safeguarding legislation as a vulnerable category requiring specialist support. We further recommend that the creation of a national research program examining the long-term social, psychological, developmental, and safeguarding outcomes of children born through organized sexual violence. The near total absence of British research in this field represents a major institutional blind spot. Mandatory training should also be introduced for all frontline NHS staff on how to identify and how to engage with various grooming dynamics: coercive control, disassociation, trauma presentation, gang-associated abuse, the boyfriend model exploitation, and honor-based abuse. Multiple inquiries have identified a recurring pattern in which professionals failed to intervene because the victims were perceived as troubled, consenting, or making lifestyle choices. Last of all, we recommend the establishment of specialist NHS child sexual exploitation units in areas with documented histories of organised abuse. These should combine forensic medicine, safeguarding expertise, mental health services, survivor advocacy, and long-term trauma support. Their purpose would be not only treatment, but also early identification of organised exploitation patterns. Every survivor should be guaranteed long-term access to specialist counselling, psychiatric treatment, sexual health care, reproductive health care, addiction support, legal advocacy, and housing assistance, regardless of whether criminal proceedings are ongoing. This is where we're going to end today's reading. Thank you very much for your time.